when it comes to Northern Ireland debates, it seems the chamber only fills up and people only take an interest when it serves their purposes for other reasons. Sadly, that is the case. I would like to see as many people take an interest in Northern Ireland affairs when we're debating other issues of real effect and practical impact on the constituents that we represent here. The timing that has been devoted to these substantial issues which have been introduced at committee stage and then in the other place has been woefully short given the gravity and the impact of them. Under Section 75 of the Northern Ireland Act 1998, there are provisions about consultation, which if we or other of the government were introducing measures which sidestep that, there would be outrage on the benches of the opposition and indeed on government backbenches and here as well. But all of that is cast aside because the ends justifies the means. And what we see is the setting aside of every parliamentary norm, every norm about consultation and consideration, every norm about the principle of devolution, because people say this place has a right to act. Of course it does, constitutionally, legally, but the reality is that we are being very, very selective to legislate on some of the most contentious and divisive issues on which there is no consensus, but leave aside hundreds of other issues on which there is consensus and on which there is common sense approach that there should be action taken. So either we have direct rule and legislate in all these areas, or we respect the evolution. You can't have it both ways, and I think we're running very close to the time now when that clear choice will have to be made. Mr. Speaker, just on the issues which sadly will get very little time, a couple of hours on Monday, a couple of hours in the House of Lords, and a few minutes here today, to change fundamentally the law on abortion in Northern Ireland, on which Roman Catholics and Protestants, Unionists and Nationalists take a very different view of many people in this House, and they have been left to one side. Their views have not been and are not going to be listened to in terms of the procedures that have now been set out. This House has inserted an abortion provision which became Clause 9, imposed in Northern Ireland whilst every member who takes their seat in this House voted against it. The Lords has now rewritten that clause, made it much more radical, so the 99 members who voted against it here on Monday now have to look at a provision which is much more radical than they voted against on Monday. It makes abortion legal for absolutely any reason, including gender and disability, up until a legal presumption of 28 weeks. And there is a provision, of course, to account for viability under the Criminal Justice Act 1945. I accept that. But the fact of the matter is that the amendment in the other place, which we are now considering, removes the main provision in our law in Northern Ireland on October the 22nd, but does not make any provision for a regulatory framework to replace it until the end of March. So we are in this limbo between the 22nd of March and the 31st of March next year, under which we may have guidelines. I hope the Minister can say something about some interim regulations that may come forward to plug that gap. But this is a very, very serious situation, and one that is really very, very difficult for most of our constituents to comprehend on all sides of the community. And the fact of the matter is that many people have expressed that outrage and feel very frustrated that this House has acted in this way. Of course it has the right to do so, but given the lack of time and consideration and consultation to take such drastic steps on a matter of such import and concern, in which there is a cross-community consensus of care, a more careful approach and a different approach needs to be taken, is, in my view, completely wrong.